Hello everyone, thank you for attending our webinar today on workforce restructuring in Southeast Asia, and notably Vietnam, Thailand, Myanmar, Cambodia and Laos. My name is Marion Carles and I am a regional legal advisor at DFDL and head of our employment practice group. For those who are not familiar with DFDL, we are a law firm specialized in emerging markets and based in Southeast Asia. We are present in 9 countries and employ over 150 advisors and more than 300 staff. We have a team dedicated to labor and employment across our various offices to ensure that our clients receive constant, seamless, and appropriate legal assistance when employment issues arise. In this webinar, we will provide lawful considerations for employers who envisage or need to take action on workforce planning to cope with the crisis and keep their business afloat. And now a quick overview of the platform we are using right now. At the bottom of your screen, you will notice several squares and applications, and notably the Q&A square where you can ask questions during this webinar. With such a large audience today, we will do our best to answer our questions during this webinar. If we don't have the time to answer your questions due to the allocated time, I encourage you to follow up by emails with your queries. You can easily find my contact details on our website at www.dfdl.com. I will now introduce our local advisors for each jurisdiction. For Cambodia, we have Vathana, who is a legal associate from our Cambodia office, and who specializes in labor, social security, immigration, and commercial law. For Laos, we have Standré, who is a senior associate in our Laos office. Standré specializes in merger and acquisition transactions, M&A, banking and finance, energy, and employment. For Myanmar, we have Nishant, who is a partner and deputy managing director of our Myanmar office. Nishant specializes in M&A, banking and finance, energy and employment. For Thailand, we have Kraisorn, who is a partner and who specializes in M&A, foreign direct investment, public-private partnerships, corporate matters and employment law. And finally, for Vietnam, we have Han, who is a partner, deputy managing director and head of our Ho Chi Minh City office. Han specializes in project finance, real estate, corporate and employment matters in Vietnam. We also have Huyen, legal associate, who specializes in labor and employment in Vietnam. Before I pass the microphone over to my colleague, just a quick update on the COVID-19 situation in our jurisdictions, where the number of infected cases actually has been and remains relatively low in comparison with European jurisdiction or in the US, for example. Currently, some countries like Thailand and Myanmar are still a curfew in force between 10 p.m. and 4 a.m., but most of our jurisdictions have now relaxed their constraining measures. While all sectors of the economy have been hit by the COVID-19 outbreak, the hospitality, leisure, retail and tourism sectors have been particularly affected by the crisis. We have been contacted by many companies engaged in this sector, which have been left with no other choice but to restructure themselves in order to face the crisis. In this webinar, we will present the various options available to employers, first in terms of internal restructuring, via notably you will see the recourse to unpaid leave, working time reduction or redeployment of staff. And second, in terms of employees layoff via the recourse to redundancy scheme or mutual terminations. Please note that the allocated time does not allow us to present each option for all jurisdictions. The intention here is more to give you a general overview of what can be implemented across our 5 jurisdictions. And now let's get started. The first option available to employers is leave arrangements and change in working conditions. I will now pass the microphone over to Vathana, who will speak about this option under Cambodian law. Vathana, it's for you.
Thank you so much, Marion, for the introduction. As part of the labor restructure under Cambodian labor law, the employer can propose the employees to take leave. The basic principle for this leave arrangement is that the leave must be mutually agreed by the employees. In other words, the employer cannot ask the employees to take leave without their consent. This leave arrangement is a common approach being undertaken by many employers in Cambodia during this COVID-19 situation, because there is no need to obtain the Ministry of Labour approval to implement such a leave arrangement. However, the employer should also take note that this leave arrangement can be interpreted as labour suspension, which will trigger the suspension process, which we will discuss in the next several topics. By law, there is no need to inform the union delegate or shop steward to implement the leave arrangement, but the employers are encouraged to at least inform those staff, the union delegate and shop steward, to mitigate any future risk. Under this leave arrangement, the leave can take form in various options, including 1. Annual leave with full salary and benefits, 2. Voluntary unpaid leave with no salary and benefits, and 3. Voluntary paid leave with full or at the reduced salary and benefits subject to the employee consent.
Thank you very much, Vatana. So speaking of leave arrangements, I believe Laos knows similar options with notably the possibility to have recourse to forced leave. Could you maybe, Standré, elaborate on this?
Thanks, Marion, and good morning, all attendees. So what we've experienced recently is that employers tend to favor restructuring their employees' leave entitlements during the slowdown of business brought about by the COVID outbreaks and lockdowns. The aim is to manage future costs by bringing down the banked leave entitlements of employees and managing their downtime while the business is slow. The labour law prescribes between 15 and 18 paid annual leave days per employee, depending on the sector in which the employee operates. As part of the, you can, of course, an employment contract or internal regulations of the employer, you may, of course, provide further leave entitlements over and above what is set out in the labour law. As part of the restructuring options for a business, we've seen and have advised employers using annual leave by either mutual agreement with the employee to take paid or unpaid annual leave, as well as the option of implementing compulsory or forced leave. Importantly, any variances in the leave policy, whether by agreement or unilaterally, will constitute an amendment of the employment terms and will necessitate written amendment agreements to be entered into between the employer and the employee, unless, of course, the existing contracts and internal regulations already caters for these variances. Unlike leave taken by way of mutual agreement, compulsory leave could only legally be implemented by the employer if the employment agreements or the employer's internal regulations provide for this right. If not, the forced leave will constitute a breach of the employment terms by the employer. In Lao, the same principle will apply to deferred or reductions in salary, as well as scaling down of work days. It's important going forward, we would recommend that employers update their template employment agreements or internal regulations or any other policy documents so that they provide the employer with mentioned unilateral restructuring options to, as an example, force an employee to take leave or deferral of salary or even implementation of a temporary suspension.
Thank you, Standré. And we see here the importance of having, an employment contract well drafted to allow, some flexibility to the employer. So I believe Thai law also requires the employee's consent before making any change to the employee's working conditions. Is that correct, Kraisorn?
Yes, Marion. Good morning, everyone. In Thailand, any form of change to working times, working hours, salary, this is considered as a conditions of employment. So if the employer want to implement certain change to this agreement already in place with the employees, the employer need to seek for consent from the employee to implement it. We have seen right now that this is the most common measures being implemented by the employers in Thailand, especially for those business operators that are significantly affected by the COVID-19 pandemic. Interesting issue under Thai law is that a consent from the employee can be obtained by either to be made in writing, or the employer can seek for implied consent. Even in terms of implied consent under Thai law, the court in Thailand has provided many rulings that implied consent can be used by the employer if they want to change this. Implied consent has been used by business operators that have a high volume of employees, for example, factory or manufacturers. This implied consent, however, require that the employee need to observe this change without any challenge for a long period of time. And in the present rulings, in many circumstances, the ruling has shown us that it requires
So it seems that we have a problem of connection with Thailand. Very sorry for that. We're going to now move to the next slide, and especially to Myanmar, which actually provides for the possibility to redeploy staff to other offices. So Nishant, this is on you. Yeah, so Nishant, this is on you. Redeployment to other offices. Apologies for the connection issues.
Can you hear me now?
Yes,
hello?
We can hear you, Nishant.
Great. So good morning, everybody, and welcome attendees. And again, sorry for the bad connection which we are facing right now. Yes, in respect to Myanmar law, we have a possibility of redeployment to other locations. Particularly, there are few aspects to be factored in such a situation, because employment and skill development law mandates that an employment contract should specifically mention the place of working. So in that situation, if the employment contract does not really envisage the possibility of deputation or redeployment in any form, then in that case a consent would be necessary. Alternatively, if the contract provides for it, then we think the employer can proceed with such an activity to redeploy a staff to a more profit-generating location. In the event there is a redeployment or a transfer of lien from one specific company to another group company, in that an event there would be a requirement that the new contract arrangements entered into And there would be a possibility that a severance may have to be paid if the lien is being transferred from the parent to another group company or otherwise. In all such circumstances, the relocation cost may have to be borne by the employer. That's all from Myanmar on this topic, Marion.
Thank you very much, Nishant. So to sum it up, the regime applicable to the change in working conditions is actually very similar across our 5 jurisdictions and is essentially based on the employee's consent. For this reason, we won't develop, this possibility further, but not that for Vietnam, for example, the same applies here. So now moving on to the next option, there is also the possibility for employers to negotiate working time and salary adjustment with the staff. In general, working time and salary adjustments are subject to the employee's consent. There are, however, some considerations that employers must be aware of. Vatana, could you maybe elaborate for Cambodia?
Yep. Thank you again, Marion. It's a good topic, actually. We receive a lot of questions from clients who are the employers asking as to whether the employers can reduce the salary and working hour of the employee during the COVID-19 situation. The answer is yes, as long as the employees agree. I would like to stress that the employee must agree to this approach. Why? Because under the Cambodian Civil Code and the labor law, reduction of working hour, salary, or any working condition affect the terms and conditions of the employment contracts. Therefore, any change to the employment contract must be consented by the employees. Otherwise, the employee has the right to terminate the employment contract. The same as civil arrangement. By law, there is no need to obtain the approval from the Ministry of Labor or unions for this plan, although the employers are suggested to at least inform the union delegate and shop stewards to mitigate any future risk. This plan can take form as one, for example, the deferred salary, under which the portion of the employee salary will be deferred to the next month or next quarter. 2, the reduction of the working hour, while there is no change to the salary and benefits subject to each employer ability. And last but not least, the reduction of working hour and salary in proportion. In other words, we call this arrangement as part-time work arrangement. Because of the deferred salary and reduced salary will impact the calculation of termination compensation in the future, it is significant for the employers to inform the employee clearly that this arrangement will impact their future termination benefit before the employee make the decision under this plan. Yes, so this is the working hour arrangement under Cambodian law.
Thank you, Vatana. And I presume in terms of information, we need to make sure, we need to advise our clients that the information provided to the employees in terms of, the salary reduction effective their severance must be clearly stated in a written document to make sure that it is understandable for the employee and we can, bring this proof before the tribunal if there is any litigation claim. So thank you for this presentation. I believe Myanmar has a similar approach in terms of working time reduction. Perhaps Nishant, you could elaborate?
Thank you, Marion. Yes, that is correct. Under Myanmar law, reduction in working hours and a prorated reduction in salary would be deemed to be a material amendment or an alteration to the already existing employment condition entered between an employee and an employer. However, there is a possibility that subject to a consent from the employee, an employer can actually, make such arrangements whereby a full-time employee is shifted to a part-time arrangement, or where an employee, where employees are actually, arranged into different slots, say day and night shifts, or an alternative day arrangement. However, again, I would emphasize that in all such situations, there is a requirement of consent and thus only upon that a prorated reduction of salary and change in hours can take place.
Thank you. Thank you very much, Nishant. So again, we caution our audience that the employee's consent is key to avoid any litigation claim based on unilateral change of salary or working conditions. And actually, I believe the same applies to Vietnam. Correct, Han?
That is correct. Hi, thanks, Marion. Good morning, everyone. This is correct. The employee e-consent is needed for working time reductions. So very similar to Cambodia and Myanmar. The working time and the salary are the other requirements that need consent from the employee, so that need to be mutually agreed between the employer and the employee. Due to the COVID-19, the employer can propose to the employee to reduce the working time, and then accordingly reduce the salary in proportions that we have seen often the practice in Vietnam these days.
Thank you very much, Han. So again, a similar option exists in the other jurisdictions, but since the legal grounds for such a change is essentially based on the employee's consent, we won't develop this further here. So now moving on to our next restructuring option, most of our jurisdiction allows a recourse to suspension of business. I believe that in Cambodia, the government has taken specific measures regarding suspension of business only applicable in the context of COVID-19. Is that correct?
That is correct, Marion. Thank you. So suspension is the hot topic in Cambodia right now. So as a general principle, Article 71 of the Cambodian labor law provides reason for employment suspension, including the suspension due to serious financial difficulty or any specific difficulty. Such suspension must be monitored by the labor inspector. Other than that, there is no detailed procedure in relation to the suspension before COVID-19. We observe that due to high demand from enterprise to suspend their employment contracts, the Ministry of Labour issued an instruction in April to provide details in relation to the suspension of the employment contract, with a scope to cover certain areas of government and tourism sectors that seriously impacted by COVID-19. Under this instruction, the suspension must be approved by the Ministry of Labour, and the application can be filed online, which is much easier for the employers. If approved by the Ministry of Labour, the employees under government and tourism sector will be entitled to the government subsidy of $40 per month during the suspension period. In addition to this subsidy, the employers under government sector must pay $30 per month to the employees, while the employer under tourism sector must pay the employee based on voluntary basis and in accordance with their ability to do so. For this procedure, the instruction does not state clearly whether the employee consent must be obtained. However, based on our experience dealing with the Ministry of Labour encouraged the employer to seek the employees, union delegates, and shop steward consent in relation to the suspension. With regard to the period of suspension, under Article 71 of the Labour Law, the suspension can only be up to 2 months in total. Interestingly, under the instruction that newly issued by the Ministry of Labour, suspension can be extended subject to approval by the Ministry of Labour. For other sectors, there is no written guidance from the Ministry of Labour as yet in relation to the suspension. We receive a lot of questions from our clients on what should they do if they are not under the government and tourism sectors. So based on our informal liaison with the official at the Ministry of Labour, we understand that other sectors should follow the same procedure as the government and tourism sectors, although the employee under other sector will not be entitled to the government subsidy.
Thank you, Vathana. And actually, I just got a comment saying that this is a very hot topic right now in Cambodia. So thank you for this presentation. And actually, just 5 minutes. So we are receiving a lot of questions from the audience. Unfortunately, there is a small delay between the presentation from each jurisdiction and the questions. So we'll do our best, to address your queries at the end of the presentation during the Q&A session. So now moving on to Laos, I believe the recourse to suspension of business is also allowed in Laos, but it seems that there is a kind of gray area as to the payment of the salary during the period of suspension. Could you maybe explain a little bit more this, Standré?
Yes, certainly, Marion. Regrettably, the position in Laos is not as clear as in other jurisdictions. Theoretically, the employer would have two options. The first relates to the much spoken about Article 111 of the Labour Law. Under this article, an employer is afforded the right to temporarily suspend its operations and only pay employees 50% of their salary. The Labour Law is not clear under what circumstances this right may be implemented and whether or not it can apply to a portion of the operations, such as a specific department, or whether it is restricted to be applied to the operations of the employer as a whole. The Labour Management Authority takes the view that its prior consent is required before an employer could rely on Article 111 of the Labour Law. Upon request from an employer, the Labour Management Authority will then engage with the applicable ministry, presumably the Ministry of Health in this instance, which ministry will then be entitled to inspect the work premises as well as the prevailing circumstances and work conditions of the employer. Only after the applicable line ministry approves the suspension will the Labour Management Authority consent to the employer relying on Article 111 of the Labour Law and proceeding to suspend its operations. Presently, the Labour Management Authority is unable to provide further guidance on things like the likely duration of the suspension, whether the suspension could be limited to some of the employees as opposed to all, or what impact the suspension would have on leave days, for instance. We were advised that the Labour Management Authority is in discussions with the Ministry of Labour and Social Welfare, the Social Security organisations, and other applicable line ministries with the aim to clarify the ambit and restrictions of Article 111 of the Labour Law. Given the uncertainty, we are not aware of instances where an employer in Laos has in fact relied on Article 111 of the Labour Law to enforce a suspension. That brings us to the second option. The second option is for the employer to rely on the force majeure provisions and the contract and tort law. The contract and tort law provides for the non-liability of a contracting party in case of a breach of contract due to a broadly defined force majeure event. Theoretically, the employer would be entitled to temporarily suspend or be relieved of its obligations on an employment agreement as a result of a force majeure event, such as a pandemic in this case. Again, due to lack of further clarifying provisions in the contract and tort law and the now recently published civil code, as well as the lack of judicial precedent publicly available in Laos, it is uncertain how successful any reliance on the force majeure provisions of the contract and tort law will be under the current circumstances. We typically advise clients to approach this contractual remedy with caution and only consider relying on this right once all of the other options have been exhausted.
Thank you very much, Standré, for this presentation. In Myanmar, I believe the regime applicable to the suspension of business is more comprehensible, but does not allow, in principle, to lower or suspend the salary during the actual suspension of business. Is that correct, Nishant?
Thank you, Marion. So, Myanmar law does recognize the possibility of temporary or permanent suspension. while the suspension of business is prerogative of the employer, depending upon its stress level. In respect to how it correlates with the employees is something which we need to factor. Employment and Skill Development Law, a relevant provision, which is Section 5D, provides that Ministry of Labour will issue a notification whereby a compensation description will be provided for in case a company is going is temporarily or permanent on a permanent basis is closing down the business. However, we understand that at present no such notification has been issued by Ministry of Labour. So the view here is that in such a situation, if an employee remains on the payroll and there is no amendment to its existing terms of condition, the full salary will have to be paid. That being said, there are alternative arrangements which can be put in place. For instance, with the consent of the employee, obviously, you can have compulsory leave arrangements with or without pay. You can have revised payment mechanisms where a portion of salary can be reduced based upon the number of hours to be put in by the employee being reduced as well. Or another option could be a deferred payment mechanism where employees are asked to defer a portion of their salary to a period when the situation becomes better, though the entitlement in such a situation would still remain. Another option, and this correlates to the possibility of termination of an employment in respect due to closure of business for reasons such as force majeure. Most of the employment contract do have pandemic, as a condition of force majeure, and thus that's how it correlates. Because the standard employment contract issued by Ministry of Labour, provides for cessation of business due to force majeure events. And in such a situation where pandemic has been declared and it would be deemed to be a force majeure, the employer may be in a position to suspend the business, and thus the termination can take place on that ground. However, in such a situation, the severance entitlement will still exist. There is one specific component with regard to workplace coordination committee, which I'll touch upon when I speak about redundancy in Myanmar's next slide. However, there is one small caveat, as we haven't really, like Lao, we haven't really come across a benchmark in Myanmar till date as to how the definition of force majeure would be interpreted in relation to the COVID situation. That being said, we would again recommend that this should be, like Lao, the last measure and not the foremost option.
Yes, thank you, Nishant. And actually, as you said, the concept of force majeure is, to be honest, rarely availed in practice, because we don't really know how, the labor courts will react, and if they will accept, a relax of the employment obligation under the employment contract. So we need to be very cautious when using, the force majeure ground. And actually, speaking of force majeure, I believe Thailand also allows employers to have recourse to the suspension of business. But again, the concept of force majeure and its application remains very unclear. Is that correct, Kraisorn?
Yes, Marion. So far in Thailand, business suspension has been the right that already been recognized by Thai court. But what has been used so far in the past is that for the business necessity reason. To put it in other words, is that Thai law provide a right, unilateral right by the employer to announce the either partial or entire business suspension on the ground of business necessity. And it has been clear with the support by the ruling of the Supreme Court that business necessity is an event where the employer has a financial difficulties, economic hardship, to the point where it cannot operate or function normally. And to invoke the right of business suspension on the ground of business necessity, the employer is required to make payment of 75% of the wage of the employees. This business suspension on the business necessity has not been used a lot in Thailand due to the high rate of minimum pay of 75%. That's why many business operators has resort to the mutual agreement with the employees to temporarily reduce the wage of the employees. However, one of the options in this business suspension right under the Labor Protection Act of Thai law, it has been viewed that in case of force majeure, there's a wording in the law saying that the employer has the right to close down the business entirely or partially, and it required to make payment of 75% in case of business necessity, and except for force majeure, where the employer is not required to make payment to make any payment under the labor under the employment agreement. So force majeure to announce the business suspension on the force majeure basis has not yet been tested in Thailand. That's why it has not been used before when this COVID-19 pandemic started. However, in late April, the Thai government, through Ministry of Labor, announced the ministerial regulations to provide financial compensation for employees that whose business has been closed or who are dismissed by the employer due to this COVID-19. And interestingly, under these regulations, the Ministry of Labor has provided a definition of force majeure that COVID-19 pandemic is a force majeure event, and if the COVID-19 pandemic affect the normal business operation of the employer, then the employee has the right to apply for financial relief from the Thai government. Even though this law issued under the Social Security law, which aim to provide financial relief to the employees that are unemployment or do not have work during the business closure by the employers. However, many employers in Thailand, when they see this law where it provides a clear force majeure definition, that if they're affected by the COVID-19 pandemic and cannot operate on a normal basis, they should use this. So to rely right now, what happened in practice is that a number of operators, especially in hospitality business, start announcing the partial business closure on a force majeure ground by relying on this definition of the Ministry of Labor regulation, declaring that this is a force majeure event. Therefore, under the law, under the labor protection law, the employer is not required to make any payment. And to ensure that the employee will cooperate with this business suspension on the force majeure event, operators attempt to convince the employees to apply for financial compensation from the Social Security. This is the current issue. However, the latest update that we received from when we have a chance to consult informally with the Social Security Office right now is that the Social Security Office reserve their right to determine on the case-by-case basis whether the employers has justifiable reasons to close down the business, whether the COVID-19 pandemic really affect their business operation, whether their business operation can still operate on a normal basis. And that is one of the reason why there's some significant delays for employees to receive the financial compensation right now. So, and because of this untested area of law where force majeure business suspension on force majeure event has not yet been tested by Thai court before, and with the concept of Thai law in general, that if the employer stop the employees from working and stop making payment of salary to the employees, this also considered as a dismissal, whereby it could trigger surrender pay obligation. And because of this two concepts that overlapping each other, business suspension on force majeure basis and the dismissal concept under Thai law, so it still remains to be seen whether the Thai court or the Department of Labor Protection and Welfare will recognize the announcement of business suspension on force majeure by relying on the definition of the Ministry of Labor regulation on financial compensation for employee in COVID-19 pandemic, will link together and permit the employer this right to unilaterally announce the business suspension. So but we expect that this clarity, we should soon have clarity on this issue very soon, because of course the employees that are subject to this announcement, from what we understand, start to making claims or complaints to Department of Labor Welfare and Protection now. So we should soon have clarity on this in Thailand very soon. So given this uncertainty on business suspension on force majeure basis, so far we encourage our client to try to seek for mutual agreement with the employee as much as possible, and so that and in practice what we have seen is that when the employers have a town hall or one-on-one discussion with the employees, explaining the serious financial difficulties that the company suffers, as well as the projection, which is not really good in the soon future. What we've seen in practice is that a high percentage of employees are ready to cooperate with the employer to pass these difficult times. We have seen in practice that over more than half, or over 70 or 80% of the employee in the business that are adversely affected by the pandemic provide really good cooperation with the employer when the employer explains these financial difficulties to implement the reduction of salary, working time, or work rotation. So this is so far the solution in Thailand, given the uncertainty of business suspension.
Thank you, Kraisorn. And actually, we have a question regarding that. I'll publish it right now. So the question is it possible to temporarily suspend only part of the business, meaning 50% of the staff?
The court, Thai court had recognized that it can be entire business suspension or partial business suspension. And partial business suspension also extend to an arrangement whereby the employers suspend the work of 50% of the workforce, and let another 50% of the workforce remain working in the business. So that is considered as a business suspension. One good example in the court ruling we have seen is that the employer can implement the arrangement of one group of employees work for 1 month and then go on leave for the next month. For that, the remaining employee that will come and work. So it's sort of work rotation arrangement. This has been done and recognized by Thai court in the past. However, I wish to note to the audience that what Thai court recognized so far, that work rotation arrangement and everything is usable as a partial business suspension, but that on the basis of business necessity ground, which require employer to continue paying every employee for 75%. So the key issue right now is that whether this same arrangement can apply on a force majeure basis. So this is the issue to remain to be seen. But however, partial suspension by having employee working into groups and have a workplace rotation is possible.
Thank you very much, Kraisorn, for this very complete presentation. I believe Vietnamese law also provides for the possibility to suspend the work for epidemic reason, and I presume this directly applies to the COVID-19 outbreak. Is that correct, Huyen?
That is correct, Marion. Good morning, everyone. In Vietnam, we spy on provision in Labor Code and the guidance from the official letter number 1064 released by the MOLISA in March 2020. Accordingly, employer can cease to work due to the direct impact of COVID-19 as a dangerous epidemic. For example, when expatriates who cannot come back to Vietnam to work or employees who are under quarantine under the competent authorities' order, so employee may request for work suspension. During work suspension periods, employee and employer may negotiate for reduced salaries. However, in any case, the reduced salary must be not lower than regional minimum salary. In the big city like Hanoi or Ho Chi Minh City, the regional minimum salary is around $200 per month.
Thank you very much, Huyen. So now moving on to our second part of the presentation. So we're going to talk about, restructuring and especially downsizing measures via the implementation of redundancy schemes, also called mass layoff. And regarding this option, it's actually quite interesting to see that the regime applicable to massive layoffs varies depending on the jurisdiction. So in Laos, I believe Laos labor law allows redundancy, provided that certain conditions are fulfilled, correct? Standré, are you here? Okay, so it seems that the connection in Laos is a bit complicated as well. So maybe we'll move to the next slide and we'll get back on redundancy in Laos. So actually, Vietnam is a very interesting jurisdiction when it comes to redundancy, in a way that redundancy in Vietnam are quite complicated and rather time-consuming because of the involvement of the trade unions. Maybe Huyen, you could talk more about this option under Vietnamese law.
Sure, Marion. In Vietnam, to implement redundancy regime, employer can spy on provision in Labor Code and the guidance from the official letter number 1064 released by MOLISA. As a negative impact of COVID-19, if employer must reduce production and reduce the number of jobs, employer can make redundancy via restructuring. If the number of employees subject to redundancy via restructuring is 2 or more, employer must proceed the following steps before any termination. Firstly, employer must prepare a labor usage plan with the participation of trade union. It means employer needs to consult with trade union on redundancies. Then employer must notify the provincial labor authority like DOLISA at least 30 days before termination date. To be prudent, we recommend employers should give employee notice periods in the same case of unilateral termination that my colleague Hanh will discuss in next slide. And lastly, in redundancy regime,
Employer must pay employee job loss allowance. Employee can get 2 months salary for their working duration up to 2 years. For employee working for employer more than 2 years, they can get 1 month salary for each working year. However, as a matter of practice, we know that the procedure for redundancy will be time-consuming. So, if possible, employers should reach mutual separation agreement with employee.
Sorry, I was on mute. So now, thank you very much for this presentation. We will now move on with Myanmar. Are redundancies very difficult to implement here, Nishant?
Thank you, Marion. Generally, redundancy is a recognized concept under Myanmar law, and as employment law basically permits termination due to such a factor, which could arise due to closure of business or necessary change of the business and general mass layoffs. However, there are a few peculiarities which have to be factored as far as Myanmar law is concerned. Now, there is a specific law which is called Labor Dispute Settlement Law, which mandates that every employer which has above 30 employees is expected to have a committee called as Workplace Coordination Committee, which is a representation of the workforce generally there by the employer in the employment. And the employer for such collective decisions have to coordinate with this committee. Now, the issue here is that we see that in practice, this committee is not in place. And we haven't even seen any specific enforcement in respect to this provision of law being mandated by the regulators. That being said, in all such situations, then in that case, the employer can directly deal and negotiate with the employees in such a situation. For the employers where they have less than 30 employees, in such a situation, they can directly deal and negotiate legally with the employees as well. Now, in all such situation, again, the requirement of severance is a must, and a notice of 1 month would be necessary. Now, the severance concept in Myanmar is gradual and increases depending upon the period of service. For instance, so there is up to 6 months of employment, there is no severance requirement. And then it doubles up from half a month's salary up to 3 years. So basically on the 3rd year, you have to pay 1.5 times the salary. And then it slabs the payment per 2 years, and which is basically 1 month increase every 2 years to the maximum of 25 years of employment, where 13 months salary would be imperative to be paid by the employer.
Thank you very much, Nishant. And actually, since we are talking about Myanmar, there is a question asked by the audience. So it's not related to redundancy, but I think it would worth addressing it. And so I'll publish it. The question is, in view of the current nighttime curfew here in Yangon, can factories be allowed to operate their night shift, 24 hours operation, but still adhering to curfew conditions by making sure that night shift workers are inside the factory premises during the said curfew hours?
That's a very good question, actually, and it's a pretty great situation. I guess recently there was a webinar by Eurocham, and I was on the panel, and this question was also raised to Uong Nang U, who's the principal secretary of the Ministry of Investment, and the concerns were raised. Our understanding is that the way presently the notification is, it doesn't really per se permit such activity. The situation is gray, and so the concern was raised, and it is only after that discussion that there has been a slight relaxation from the previous imposition of curfew. So in respect to the timing thereof. So our view would be that while it may not sound commercially sound, there is a little bit difficulty here, and curfew conditions will have to adhere strictly.
Thank you, Nishant, for this answer. So in Thailand, I believe the situation is a little bit different than in Vietnam, for example, or Myanmar, since the unions have a less strong presence in the employment landscape. Is that correct, Kraisorn?
In terms of redundancy, there is no involvement by the authority or by the union required by law. So the employers has the liberty to consider the redundancy arrangement. However, the redundancy arrangement must be made with very cautious manner because of the potential claim on unfair dismissal that may arise in the process. So redundancy can be implemented by the employer, but the employer is required to make payments of all minimum entitlement required by law. For example, advance notice of termination, surrender pay payment, because this is considered as a termination without misconduct by the employees. And the last issue is unfair dismissal. Unfair dismissal has two key bases that the employer need to comply when considering redundancy. One is the justified cause. It has been recognized by Thai court in many rulings that economic hardship and financial difficulties, accumulated losses, is one of the justified ground for the employer to implement the redundancy arrangement. Another issues that the employer needs to consider is the process or procedure of redundancy. The Thai court may explore and examine on whether the company has explored all the options instead of before choosing redundancy, and if the employer can prove that redundancy is one of the necessary option to keep the business survive. Another aspect that Thai court can examine would be what is the process of the selection of employee to be subject to this redundancy. So the employer need to also ensure that the selection process of the employee to be made redundant must be fair and indiscriminate. The employers can resort to the performance indicators that it has internally, or level of seniority, level of experience. So those objective, provable indicators must be used when considering the employee to be made redundant. If the employer can comply with these two elements, justified cause and fair process, then it will not be subject to unfair dismissal compensation. However, in practice, since unfair dismissal compensation must force employer and employee into the litigations, and it's a time-consuming and costly process. In practice, the employer always try at best to seek for mutual separation first before put the employee on redundancy unilaterally. In that case, the employer can avoid the litigations and can also avoid a lot of cost and expense in relation thereto. So what the employer do in practice in successful redundancies is that, of course, the employer need to pay all minimum entitlement under Thai law and under the work regulation that the company has. And the employer will need to offer additional financial support so that it can encourage the employees to cooperate and enter into this mutual separation, whereby the employee will waive all the right to take action with respect to the employment agreement. So that has been the option that been implemented successfully in Thailand, and it has been the most common one. But of course, so far in this COVID-19 pandemic, redundancy has not yet been an issue because of the financial package that it accompany with, which could affect the cash flow issues that the company is really want to avoid right now. Therefore, again, as I said previously, mutual agreement with the employees on the work condition arrangement or readjustment has been implemented so far.
Thank you very much, Kraisorn, for this presentation. And actually, I think Laos is back to the presentation. Standré is here, and so maybe we could go back to the redundancy regime in Lao PDR, especially because we had a question on this topic. So it might be interesting for our audience to have more information on that in Lao.
Certainly, Marion. Apologies for the little comfort break there. As with most jurisdictions, an employer in Laos can terminate an employment contract for business reasons, provided that it first consults with the trade union or employees representative or a majority of the employees, and it also notifies the Labour Administration Authority for the impending redundancies. As a redundancy is classified as a justified termination ground, severance will be payable at a lower multiple of 10% of the last salary of the employee times the number of months worked with the employer. Importantly here is that the labour law only requires the employer to notify the Labour Management Authority, and its approval is not legally required. However, practically, if the Labour Management Authority in its discretion finds insufficient justification for the redundancies, the Labour Management Authority may deem the termination to be unjustified due to insufficient reason for termination. Unjustified termination attracts a higher severance liability than justified termination, being based on a 15% multiple. The risk can thus be monetized by the difference between the 10% and the 50% multiple in the severance calculation. Lastly, regarding the notice to the employees, any notice of termination due to business reason issued to the employees should be accompanied with the statutorily imposed notice period given to the affected employees, being 30 days for unskilled and 45 days for skilled labour.
Thank you very much, Standré. Actually, we have a question for Lao regarding redundancies. What if an organization may need to conduct redundancy plan? Do we need to obtain approval from Ministry of Labour? I think you already answered this question. And what will be the compensation like?
Yes, so if the Labour Management Authority in its discretion find that there are sufficient reasons for the redundancies, you would be entitled to apply the justified termination severance calculation, being the 10% of the last salary of the employee times the number of months worked with the employer. If the Labour Management Authority or any employee disputes the justified ground for termination, and the Labour Management Authority deems the termination to be unjustified, your 15% multiple will apply to the severance calculation.
Thank you very much, Standré. So to sum it up, the redundancy option, also interesting for employers, presents some risk, especially in terms of litigation, since the employees can still challenge the grounds and admissible cause for termination. For this reason, we normally, encourage our clients to have recourse to mutual termination with their employee. Maybe Vatana, you can explain how mutual termination works in Cambodia?
Yes, Marion. Yeah, thank you. So, similar to other jurisdictions, redundancy or unilateral termination is available under Cambodian labor law as well. However, redundancy or unilateral termination will give rise to many considerations, including the consideration that is related to mass layoff and approval from the Ministry of Labour. As an alternative approach, mutual termination is recommended. Mutual termination means that the employer and the employee must agree to terminate their employment contract. The agreement must not be with any force. The good point of this approach is that there is no need to get the approval from the Ministry of Labour other than the requirement to sign the mutual termination agreement in front of the Labour Inspector for fixed duration contracts. There is no requirement to inform the union delegate or shop steward as well for the mutual termination, but the employer are suggested to do so if there are many employees involved under this mutual termination option, and especially during this COVID-19 situation. In terms of the termination benefits, mutual termination package, because it is mutually agreed, it is subject to agreement between the employer and employee. That is, the labor law does not state the specific amount of the package. Nevertheless, to mitigate any future risk, it is recommended that the employer provide full termination benefits as in case that the employer terminate the employee without any cause. This wrap up the mutual termination in Cambodia.
Thank you. So yeah, we appreciate the flexibility under a mutual termination arrangement, provided always that, you know, the severance and amount paid by the employer is kind of sufficient enough, you know, otherwise the employee will, you know, would probably challenge the agreement made with the employer before the labor court. So as we were saying, the mutual termination minimizes the risk of labor claims in most of our jurisdiction, but there are some others like Laos where when this option actually may raise issue, especially regarding the employee's consent. Is that correct, Standré?
Yes, correct, Marion. So just briefly on mutual termination. Mutual termination will effectively equate to voluntary resignation. Under the labour law, no severance is payable to an employee who voluntarily resigns. However, as with Thailand, compensation may of course have to be included in an offer put to the employee to agree to resign. The risk with offering voluntary resignation is that the offer may be seen as a constructive dismissal. Constructive dismissal is deemed as termination without sufficient reason and unjustified. Again, unjustified termination describes a higher severance liability than in cases of justified termination, using that 15% multiple as mentioned. I might just add that the situation in Laos is still developing. At present, the employer's options for labour restructuring are generally limited to instances which require cooperation with the employees through amendments to the employment terms. And of course, any unilateral termination will attract severance liability, whether it be based on the 10% or the 15% multiple. Regulatory relief is available, but presently doesn't include clear guidelines on any unilateral right of an employer to suspend operations without the intervention of the authorities. Again, just for going forward, employers need to consider amending their template employment agreements and internal regulations to afford them that right to unilaterally implement changes in employment terms.
Thank you. Thank you very much, Standré. So again, just for our audience to understand, a similar option, meaning the mutual termination option, exists in the other jurisdiction. But since, you know, this option is essentially based on the employee's consent and the agreement of the parties, we won't develop this further, but just know that it is of course possible to enter into mutual separation agreements under Vietnamese law, Myanmar or Thai law. So now we're going to move to our next option in terms of downsizing. And so when no other options are possible, employers can still have recourse to unilateral termination on the grounds of force majeure. This is notably permitted in Vietnam, and I will now pass the microphone over to Han, who will provide lawful consideration as to this option under Vietnamese law.
Sure, thank you, Marion. Yes, indeed, under the Vietnamese law, it's possible for the employer to have the recourse to unilateral termination of the labor contracts due to force majeure event. However, the employer must respect the conditions of the force majeures. The very first condition is that the employer then would have a force majeure event. This is a force majeure event defined under the general law, notably the Civil Code of Vietnam, that event would be occurs, which is an event occurring in objective manners, and which cannot be, it is not able to be remedied, or only necessary measures has been not able to be remedied by all necessary and possible measures. From a Vietnamese law labor perspective, the employers here must also have taken all necessary measures to remedy to the problem caused by such force majeure event, but it is still need to reduce the number of jobs. The final condition is that the employer must respect the prior notice. The prior notice in respect of termination in this case, 45 days for indefinite contracts and 30 days for definitive contracts. The Vietnamese law, there is an exception to this case. The employer cannot terminate unilaterally terminate the labor contract in case the employee is infected by the COVID-19 during his or her sickness, unless such employee has undergone medical treatment. And this is a period of medical treatment is also depend on the period, on the type of contract that the employee has with the employers. So, for example, 12 consecutive months in case of employment contract under the indefinite term contracts, 6 consecutive months in case of the employment under definitive term contracts, and more than half term of the contract if the employment is under a seasonal labor contracts.
Thank you very much, Han. So maybe we're going to sum up a little bit what we discussed so far. So basically, the options chosen by the company, by the employer, will largely depend on the financial capacity of the company to face the crisis on a temporary or more permanent basis, as well as their forecast for the coming year. When restructuring measures can still be implemented, such as a deferment of salary or working time reduction, then the employee will play a key role in the process of implementing the restructuring options, since his or her consent will be necessary to implement the changes. For this reason, we generally advise our client to have a transparent discussion with their staff, and so that they understand the difficulties sustained by the company right now. When, despite all efforts undertaken by the parties, restructuring measures are no longer sufficient to keep the business afloat, then companies must envisage labor cost reduction by terminating employees. As previously discussed, the option of mutual termination is generally preferred, as it secures the termination and minimizes the risk of labor claims. So maybe now let's go over some of the questions from our audience. So maybe we're going to start with Vietnam. So we have a question for Vietnam. I will publish it. So it says that the Vietnamese presenter said that employer and employees can negotiate a reduction in pay as long as it does not go below the minimum wage. If an employer decides to offer the minimum wage, does that mean that the employee can still opt against accepting the minimum wage? Is the alternative for them to hope for a favorable decision in the courts at some of the future dates? So I believe the question is, can we go lower the Vietnamese wage by the minimum wage, by mutual agreement?
Thank you, Marion. Thank you for the questions. So yes, the question was like, is there the employers and the employee agree on the mutuals on the minimum wage, and whether the employee can opt against this. Technically, the situation, the COVID-19 is one of the situation called a natural disaster under the Vietnamese labor codes. And in this situation, the reduction of salary is indeed subject to mutual agreement between the employer and the employee, but it cannot go lower than the minimum wage of published by a province or city in Vietnam. So indeed, to respond to the question, if the employee can opt to against that, then yes, the answer is yes. This is because it's subject to negotiation between the employer and the employee to find a balanced situation. In this situation, we recommend to the employer and the employee to find a balanced solution or position in terms of salary in these situations.
Thank you very much, Han, for this answer. So we have now a question for Thailand, and actually it refers to one of our first slides. Can we have, Kraisorn, an example of implied consent? I presume for what relates to the change in working conditions.
Yes, implied consent in practice is simply to deal with a high number of employees. Is simply an announcement or town hall by the employer. It could be in writing, it could be as a verbal announcement, but most of the time it will be a written announcement provided to the employees or to the affected employees. And the proof of implied consent is what, as I previously said, that the employees must have observed. There is a clear fact that employee observe without any challenge for a long period of time. What is the easy example on this? For example, if you reduce salary of the employees, at the end of the month, company make payment of salary to the employee, and employee does not provide any challenge, does not give any objection, and receive the payment without any question. If this continue for a number of months, then it could be viewed that implied consent has been received from that affected employees.
Thank you. Thank you very much, Kraisorn. So now a question for Cambodia. So in Cambodia, is cost cutting due to low sales be a valid reason for having employees take mandatory leave?
Thank you, Marion, and thank you for the question. So unfortunately, under Cambodian labor law, mandatory leave is not available. That is why in the slide, we only raise 3 options: annual leave, voluntary paid leave, and voluntary unpaid leave. So if the employer experiencing the reduction of sales, then if there's like a reduction of the business operation, the option that the company can do is to submit the request to the labor authority, the Ministry of Labor, to suspend the employment contract. So as I mentioned in the presentation, if the Ministry of Labor approve the suspension for the government sector, there will be a government subsidy of $40 per month, and for tourism sector, then there will be also $40 subsidy per month. Other sector, there will be no subsidy.
Thank you very much, Vathana. So now a question for Laos. So in Laos, the asker asked, if we take the reducing working hours and reducing wages, it should be applied entirely to the company or partially, or can it be applied partially due to business nature or workload?
Yes, so if an employer would like to implement measures like deferred salary or salary reductions, or reductions in the number of work days, all of these would constitute amendment of employment terms, and it needs to be agreed in writing by the individual employees. The only exception to this would be where your existing employment agreements or internal regulations or any other policy document to which the employee is contractually bound already caters for this option and the right of the employee to unilaterally implement. Other than if it's already catered for in those documents, you would have to reach agreement with the employee across the board. For each employee, you would need to amend the employment terms by way of a written agreement.
Thank you. Thank you very much. Thank you very much, Standré. So I have a question for Myanmar. What will be the option for Myanmar in terms of suspension of business, force majeure events? It's a very general question. I don't know if you want to add further considerations. Nishant, you already present suspension of business in Myanmar, but yeah, if you want to add something.
I have touched upon it, Marion, and to sum it up, it basically means either we restructure it through mutual consent, or there could be termination subject to severance payment. And in the latter case, there has to be at least a month's notice, or a notice period as may have been envisaged in the employment contract, which may be above a period of 1 month.
Thank you very much. And actually, a last question for Myanmar before we close this Q&A session. So if the work location of salespeople are closed, example, beer station, restaurants, etc., meaning the employees cannot do their job, so they are staying at home, can we force them to take unpaid leave or any other leave?
So see, with respect to the paid leave, if the employment contract has envisaged a point where certain paid leave can be taken in a certain period of time. For instance, most of the schools you'll see in Myanmar are providing for paid leaves to be taken only during the school holidays. So in that case, you can go ahead and do it. Otherwise, you will have to get a sort of consent, because by the end of it, leaves are prerogative of the employees as and when they would want to take it, subject to certain policies which may be in place. In respect to leave without pay, this goes back to the first question which was raised to Myanmar during my presentation. Sorry, the presentation I gave on my first slide. In general, leave without pay would be possible if the employee consents, which is a situation you have to factor, because in absence of a consent, you might not be allowed to do it.
Thank you very much, Nishant. So just a last question for Vietnam. So if the employee agrees to leave without pay, is it legal if the employer does not pay the minimum wage?
Thank you, Marion, and thank you for the question. Yes, in this situation, then yes, it is legal for the employer that not need to pay for the minimum wage. Of course, what I would like to add here is that the employer and the employee must document properly the agreements of the employee agreements and consent for to take leave without pay. I hope I answered the questions.
Yes, thank you very much, Han. Actually, the option of leave arrangement interests a lot our audience. We have another question on this for Thailand. So relating to leave for Thailand, does employer have the right to enforce employee to take annual holidays when the business is down during this situation? And what if we want to change the policy of leave carryover? It means allowing employers to carry forward their leave entitlement of 2020 to 2021. Do we require to get a consent, or can it be done by just making an announcement to all employees? So it's actually a lot of questions for Thailand.
Yeah, it can sum it up that for paid holidays, there are paid holidays and unpaid leave, right? Paid holidays, the employer has by default of the law, the employer has the right to unilateral determine the annual holiday, paid holidays to employees. However, in practice, you need to be sure that your work regulation do not say otherwise, because it has been a practice in many years in Thailand that the employer and employees decide to use the application and approval system rather than having the employer to unilaterally determine the annual leave of the employees. So if the work regulations still allow the employer to unilaterally determine the annual leave of employees, then the employer can do that. But that's, we talk about the paid leave. So to put unilaterally put employees to unpaid leave, that is not possible under the law. You need a consent from the employee. Otherwise, you need to resort to the partial business suspension that we have discussed earlier in this talk. And another issue about the chain of the leave policy going forward, as we raised in at first, that any term resulting in change of working time, working hours, salary, leave policy is also one of this, is considered work condition under the Labor Relations Act, whereby any change thereto which could create adverse effect to the employees require a prior consent before implemented. But again, as I have raised, that in practice, Thai court had recognized implied consent, that it can be used in the process of change of leave, of policy or work regulations. So there's a number of business operators that simply unilaterally announce the change to the work regulation or leave policy in the hope that there will be no objection from the employees. The issue will be that if there is a challenge or objection by an employee, that employee will not be bound by the change to the work regulation or leave policy. So this will be the issue. But in the past, when the employee does not have high awareness, like this COVID-19 pandemic, it has been used quite relatively well, smoothly. We have seen only a few cases of objection when the, for example, factory or manufacturer announced the change to the work conditions or work regulations, especially any work conditions change to the work regulation that affect pay and leave. I think this type of change could be subject to high possibility of objection from the employee. So to use implied consent, the employers need to be very cautious about this, because if you receive objection, then there's a possible labor dispute that could happen to the company. Yeah.
Thank you very much, Kraisorn, for this answer. Unfortunately, we would need to end this Q&A session because of the allocated time, but I encourage you to follow up by email. I would like to thank our speakers. As I said, if you have any more questions, please feel free to contact us directly. You can find our email address on our website. This session has been recorded, and will be available next week on our website. You will receive the full presentation slide after the webinar, together with the link with the feedback form. I would love to hear from you. I also invite you to visit our COVID-19 hub on our website, where we have put forward interesting articles relating to COVID-19 and its implication on HR and labor and employment. I'm Marion Carles, and I'll see you next time.